Hi, my name is Lizzie Chan, and I'm a member of the CPR Institute's Young Leaders in Alternative Dispute Resolution Steering Committee. I'm delighted to host today's episode of our CPR Y-ADR Corporate Counsel interview series. Y-ADR seeks to educate the next generation of leaders on the full spectrum of dispute prevention and resolution mechanisms, and to provide an insider's view into CPR's community of in-house counsel, external counsel, and other experts in the field on how they're using dispute prevention and resolution techniques to manage conflict to enable purpose. As part of this goal, we're going to be asking questions from corporate counsel to share their best practices on ADR and their career advice for young practitioners. Today, I am delighted to welcome John Packer, who is Senior Legal Counsel at Bechtel, based in London. Hi, John. We're so happy to have you here with us today.
Hi, Lizzie. Very, very pleased to be with you this morning. You know, this is a fantastic initiative, and very honoured that you've asked me to be a part of it.
Thank you so much for being here. And my first question for you is, can you tell us a bit about your career experience and your role at Bechtel and the types of disputes you're involved in?
Sure, of course. So I trained in London. I qualified into the construction department of a private practice firm. At the time, I had no real link to or experience in the construction industry, other than a 6-month placement as part of my training contract. So I guess my only real qualification was a keen interest in how things got built, and a sense that there would always likely to be a strong demand for construction lawyers. And I was also aware that it would allow me to do both contentious and non-contentious work, and therefore get a very broad experience. So, you know, I would really encourage all young lawyers to consider specialising in construction. Maybe I'm just a bit biased, but I would encourage them to do so. You know, the technical side and all the jargon can be daunting, but if you've got a good grasp of contract law, I think there really is nothing to fear. As I say, it's a real opportunity to work in both the contentious and the non-contentious side, and I think that balance is really important, especially in the early part of your career. And also there's lots of opportunity to travel. Well, certainly there was pre-pandemic. So I guess to illustrate the point, I worked in private practice for a number of years in the UK before relocating to the UAE in 2011, and I was still in private practice at that stage. So I worked in the UAE for a number of years before moving in-house with Bechtel about 3 years ago. So my current role, I concentrate on resolving disputes in large infrastructure projects, but I also advise on the drafting of dispute resolution provisions before contracts are signed. You know, it's good, it's rewarding to be able to actually shape what the dispute resolution process is going to look like. You know, that really is the right stage to start thinking about how disputes are going to be resolved, you know, at the pre-contract stage.
Can you tell us a bit about the factors you take into consideration when you're drafting a disputes clause? For example, will you use a combination of different ADR tools like mediation and arbitration and adjudication?
Yeah. You know, I think mediation has a role to play. And I'm a big fan of dispute adjudication boards. I know that the CPR is currently working on a number of things on the DOE front, and you know, I very much welcome that. The evidence is pretty overwhelming that DABs are effective at resolving disputes quickly and satisfactorily. It's extremely rare that DAB decisions are subsequently challenged. The majority of them are complied with, you know, and I think certainly a tiered sort of a tiered dispute resolution process it would be my preference in the majority of cases.
I'm really interested in your comments on adjudication, as you're the first interviewee in our series that's mentioned DABs. What types of disputes do you think are particularly amenable to this form of ADR?
Yeah, so I think the vast majority of disputes actually could go to DAB. It's a lot of the practitioners who work in the DAB field are arbitrators themselves, and so will have an experience of arbitration. Excuse the noise if you can hear that. Working from home issues. So yeah, I think DABs can. The DAB process can be used for virtually any number or type of dispute. I don't see that we necessarily need to constrain that. I think DABs work well certainly in the construction industry, where it allows the parties to actually resolve disputes on a almost sort of real-time contemporaneous basis, and I think that's one of the keys to the attraction of DABs, that you actually get a resolution at an early stage, as opposed to doing what the construction industry has traditionally liked to do, which is to park disputes and focus solely on completion before completion of the project, before turning attention to the resolution of disputes. I think it's important to manage and resolve disputes at an early stage, before they do become these big behemoths of arbitration or litigation.
And I can completely understand that, having waited several years for some of the awards and some of my cases. And we talked a little bit earlier about cost and budgeting. What do you think are some best practices in these regards?
Well, I think I guess it goes back to what we were talking about before. I think we really need to think carefully and strategically about how we do things. Before the COVID pandemic hit, the default in arbitration was to convene a big in-person hearing of the parties counsel, witnesses, experts, tribunal. Fly them in from multiple locations around the world and put them up in a swanky hotel and argue it out over the course of a couple of weeks, if not longer. Whilst there was a movement towards remote working and virtual hearings before the pandemic, I think this has been obviously massively accelerated, and I guess we've been forced into a bit of a paradigm shift in the way we work. A shift which many people will have thought impossible only a couple of years ago. So I think we should really bear that in mind when we're thinking about how we approach disputes and how we draft our dispute clauses and how we manage the costs of arbitration. I think there is really a scope for some really kind of innovative and radical thinking when it comes to doing things. Obviously, the best way of keeping arbitration costs down is not to go to arbitration in the first place. Early ventilation of disputes is clearly key, that goes back to what we were talking about before in respect of drafting of your dispute clauses, and looking at alternative means of resolving disputes, whether that be mediation or DAB or other structured negotiations. You know, I think then once you're in arbitration, and I think we have to acknowledge that sometimes arbitration, unfortunately, does become inevitable. You know, it's not as inevitable as perhaps we tend to think in the legal industry, but you know, sometimes it is unfortunately unavoidable. Once in arbitration, I think there are a number of ways which you can try to keep costs down. The first, I think, is it's obviously important to choose a good and experienced arbitral tribunal. You know, it may be obvious, but it's certainly, I think, something to remember. You need a tribunal which is prepared to be robust and won't be, you know, easily persuaded to agree extensions of time or give in to other delaying tactics which the parties can employ in arbitration. You can consider whether to have a sole arbitrator as opposed to a 3-person tribunal, you know, perhaps subject to a materiality threshold. You can consider having a fast-track arbitration to condensing the time for award. Again, you know, could be subject to a materiality threshold. I would say generally try to resist bifurcation. This does tend to lead to increased time and cost. Although, excuse me, there are sometimes circumstances where bifurcation, you know, is a sensible option. You know, if there is a key point, for instance, that can be taken early, and you think you're confident in your chances of success on that key point, and it might then unlock a settlement, then consider bifurcation. But as a general rule, I would say try to avoid it. I think you would also try to keep a limit on disclosure. You know, I was once told by a supervisor that in any dispute there were only likely to be 10 or so documents that fundamentally mattered, you know, that would really have a material outcome to the dispute. You know, one of those would be the contract. And I think that's so true. I think, you know, we can sometimes be overwhelmed by the sheer amount of documentation involved in construction and international arbitration generally. But I guess it's key to try to really focus on what's important and make sure that there is a sensible limit kept on disclosure. And you know, I think there are you can also keep a limit on other things like the number of witnesses, for instance, and also think about whether you really do need to cross-examine each and every witness. You know, I think if we've been shown anything by this pandemic, it's that we can really rationalize and work smarter in terms of the numbers of individuals involved and how we approach hearings, so that, you know, there's no reason to think, there's no reason to sort of to go back to business as usual or to proceed as we have in the past with huge numbers of witnesses and so on. You know, with a bit of thought, I think things can be rationalized.
You've raised so many interesting and great ideas for how we can make disputes more efficient. And I definitely think that the elements you've raised, I think, you know, external counsel should be in mind as well as we work with the client to develop a strategy for dispute resolution. I'd now like to pivot to questions about your career and your advice for young practitioners. So what is your advice for young practitioners in the ADR field?
Good question. So I think the highlight, the principal thing I'd like to get across is that we shouldn't just accept as a reason for doing things the fact that we've always done them that way. Yes, there are often good reasons behind established procedures and processes, but they should always be used mindfully, I think, and kept under review. So I think there really is a key role for junior lawyers to bring the fresh perspectives. So there's a key role to be played even by the most junior of lawyers. I know it can be incredibly difficult to challenge the orthodoxy, especially when you're just starting out in your career. I was certainly not always confident enough early in my career to question things in the way that I perhaps could have done. So my advice would be, obviously find your feet, but then challenge things without being difficult for the sake of it. If you do that, then at the very least, I think you will gain a really good understanding of how your business works. And if you take the time to think critically about things, and ultimately, I believe your supervisor will be pleased that you're taking the time to really consider whether there is a better way of doing things. And as I say, at the very least, you will understand why the business does things in the way it does. So I think there's a real opportunity for the next generation of lawyers to lead the way when it comes to how we do business and how we resolve disputes. I would, just another word on that, I think I would really encourage young lawyers to get involved with organisations like the CPR, and also really embrace technology. Use your understanding of technology to try to come up with innovative ideas to help us resolve disputes and drive down the costs of resolving disputes. Pretty much since I was first started out in my career, there's been talk of technology making the job of lawyers redundant, but that's not really happened. We still need people to really understand and apply the technology that's coming through, and I think that's where the next generation of lawyers can really get involved and make a huge difference.
Thank you so much for your advice. And I should tell our audience too that the reason we met is because we both serve as members of the CPR Y-ADR Steering Committee. And just building on your last answer, John, what are some specific things that junior and mid-level associates can do to understand the client's business better?
Well, I think the key when working with in-house practitioners is firstly you need to have a good grasp of the fundamentals. So I think the black letter law that you're advising on, and the industry in which your client operates are key. But once you've got those fundamentals in place, I think then it's a question of trying to have that conversation with in-house counsel and actually really try to understand what it is they're looking for. Try to preempt as far as you can, and I know it's difficult, but try to preempt as far as you can what they require. Put yourself in their position in terms of when you're thinking about deadlines. If you're agreeing a deadline for a specific document, bear in mind that there are going to be all sorts of internal approvals, potentially internal approvals required for that document. So if you have a deadline in arbitration, it's not that's not really necessarily the deadline. the deadline could be several days, if not weeks before that. Actually really sort of try to take time to understand the in-house counsel position, to really sort of try and understand the structure of the corporation that you're working for. As in-house counsel, I'm very happy to take the time to discuss that with external counsel if they ask me, to actually explain the structure, who is who, and how we operate. So I think have that conversation early on, set expectations, and ultimately as in-house counsel, what we're looking for is delivery of the defined deliverable on time and on budget, and if you can achieve those, you're well on your way to making yourself a trusted advisor of the in-house counsel, and that's ultimately what you're looking to achieve.
Thank you for giving young practitioners the confidence to reach out to in-house counsel, because I think that's something many young practitioners might be afraid to do. And now I've got one final question for you. You've been based in the Middle East for over 10 years, I think. Is there anything about your experience in that jurisdiction that you would like to share?
Well, I thoroughly enjoyed my 10 years in the Middle East. It was a fantastic experience. I think it was at that stage in my career, it was great to jump into a new challenge. Change is as good as rest, as they say, and it was great to move out to the Middle East. I worked on some fantastic projects and issues, and it was very rewarding stuff to work on some of these large infrastructure projects. It was also interesting different working practices, and actually being based in the UAE was great. And it depends how you look at it, really, but it was great in terms of being involved across multiple jurisdictions. Obviously, starting in the morning with working with Hong Kong and Singapore in the east, and then working your way westwards, working with Europe, and then if you were unlucky enough to still be working when they got up in the States, you could continue. So certainly good. Probably better for younger, more energetic individuals, as I think I was at that stage, I think it was fantastic. So I would certainly encourage younger lawyers to take any opportunities that are available, to expand their experience and expand the geographical remit of their practice. And I guess one of the good things coming out of the shift that we've been talking about is the fact that you can now there is even more scope to work across multiple jurisdictions and time zones from your own home. So there's no reason not to sort of really get involved in that if you want to.
I completely agree with you, and I feel so lucky in my career to have worked in a few different jurisdictions in Hong Kong, New Zealand, London, and New York. And it's so wonderful that we can connect via Zoom, you in London and me in Hong Kong. Well, it remains for me to thank you, John, for your time today and the wonderful insights that you've shared. And my thanks to our audience for tuning in.
Thanks very much, Lizzie. Pleasure speaking with you.